I'm Scot Douglas, the staff attorney with Veterans Legal Institute and an Army veteran. And I am the primary staff member responsible for the estate planning clinic. Sheila-Marie Finkelstein, an attorney in private practice who was a state bar certified specialist in estate planning, also a military spouse. Her husband is a naval veteran. She and I began the clinic in 2017, initially holding the clinics in person in the Veterans Legal Institute offices in Santa Ana. Over the past several years, we have shifted to holding the clinics virtually via Zoom. This shift has resulted in a need for volunteer pro bono attorneys to assist those veterans who are not technically proficient. I do want to let you know that this is general information only that is current in February 2023 and California law applies. This is not legal advice, and we are not establishing an attorney-client relationship. The topics we're going to cover today are about the estate planning clinic, the application process, assessing capacity, estate planning documents, trust funding, and benefits.
Our first topic is the estate planning clinic. Scott and I formally established the estate planning clinic in 2017. The clinic is typically held on the second Thursday of each month. Originally, the clinic was held in person in our Santa Ana offices. However, due to the COVID pandemic, we've switched, and now all of our clinics are held remotely via Zoom. In our clinic, we handle most general estate planning needs and basic probate improper assistance. You should apply for the Veterans Legal Institute Estate Planning Clinic if you are an individual over the age of 18 with or without real property, particularly if you have real property, and particularly if you are unmarried. If you are married, you should also apply for the Veterans Legal Institute Estate Clinic because we need to create a plan for you too. Again, apply whether you have real property or not. You also should apply for a plan if you already have a plan, whether it was a plan that you created for yourself or a plan that another attorney created for you. Apply for services with the Veterans Legal Institute Estate Clinic so that we can review your current plan and make sure it is up to date, not only with the current laws, but also with your changing life. Did you create the plan before you were married and now you're married? Did you create the plan before you had children and now you have children? Did you create the plan when you had children who were 3 and now your children are 23? The estate plan is a living document that needs to constantly be updated to reflect where you are in your life at this time. You should also apply to the Veterans Legal Institute Estate Planning Clinic if you have a prior plan for which you are a beneficiary. We can review that plan for you and let you know what you are entitled to receive under the terms of the plan for which you are a beneficiary. You should also apply for assistance with the Veterans Legal Institute Estate Clinic if you need help with probate. We can help you prepare the judicial counsel forms that are necessary for the probate process so that you can represent yourself in court and save the cost of attorney's fees. Sometimes when you apply for the Veterans Legal Institute Estate Clinic, we will actually end up referring you to one of our pro bono attorney volunteers. This will happen for a few reasons. One, if you cannot participate via Zoom, we want to make sure that we are able to assist all of our veterans and their families. Right now, our estate clinic is held entirely remotely via Zoom. So if you're unable to participate via Zoom, we like to set you up with one of our volunteer attorneys so that they can help you in person in their office. We'll also refer you to a pro bono volunteer attorney if you do not have an email address. This falls in with the Zoom category. We need to be able to communicate with you electronically in order for the estate clinic to work. So if you don't have an email address, that's okay. We'll make sure to connect you with a volunteer attorney who can help you in person. We may also refer you to one of our pro bono volunteer attorneys if you have complex estate planning needs that we do not have the capacity to help within our monthly estate clinics. And then we might also refer you to a pro bono volunteer attorney if you want more assistance with the probate process. So within the clinic, we can assist you with preparing the documents on your behalf so that you can represent yourself. But if you find that you want an attorney to step in and prepare everything for you and represent you in court during the probate process, then we will connect you to one of our pro bono volunteer attorneys. And finally, you might be referred to a pro bono volunteer attorney if our estate clinic is full. We want to make sure to help as many people as possible, as quickly as possible, which means sometimes we handle it in-house through the estate clinic, and sometimes we send you to one of our wonderful volunteer attorneys. Next, we're going to talk about the application process. So you've probably already figured out that you need an estate plan for one reason or another. And the first step in doing that is applying at vetslegal.org. Once you've submitted your application, you will receive a phone call from Veterans Legal Institute, probably from Scott himself, and he'll ask for additional information and explain the engagement agreement process and the Zoom. The type of information we'll need is to determine whether you're married, whether you have children, whether this is going to be a general estate plan or a complex estate plan. At this point, we will determine whether you will be referred in-house to the Veterans Legal Institute Estate Clinic or whether you will be referred to one of our pro bono volunteer attorneys. If you are selected for in-house, then you will receive an engagement agreement. This is the agreement that says the services that we will provide for you. And once you agree to that, you will receive your questionnaire. We'll make sure to send you the appropriate questionnaire, whether you're an individual or whether you are married. And that questionnaire will provide us with the overview of all the information we will need to prepare an estate plan in accordance with your individual needs and wishes. Once we receive that questionnaire back from you, you will be scheduled for the next Veterans Legal Institute Estate Clinic. As mentioned, that's usually on the second Thursday of the month, so the sooner you get it in, the sooner clinic you'll be assigned to. During that clinic, we will meet remotely via Zoom with Scott, myself, and you and your spouse, and we'll discuss all of your needs and wishes and design a plan that fits your specific scenario. Once we've designed that plan, we'll draft your estate plan, and Scott will send you a summary for your review. Once you receive the summary, please look over it carefully, as we attorneys are human, so there may be name misspellings that we want to make sure that is spelled absolutely correct. We want to make sure that addresses and birthdays are correct, and we want to make sure that your wishes are outlined exactly as you would like them to be. Once you've reviewed the summary and it meets with your approval, we'll schedule you for your remote online notarization. The remote online notarization is a process that is similar to DocuSign and Zoom. You will authenticate your identity much like you would with a regular credit check, mother's maiden name, first street you grew up on, so on and so forth, and show your driver's license or valid government ID on video. And once your identity has been confirmed, you will be able to electronically sign all of your documents, which will then immediately be available to you and to Veterans Legal Institute. If for some reason a remote online notary is not an option, if there's technical difficulties, whatever the case may be, then we will either schedule you to come into the office for notarization, or we will print and mail the complete portfolio to you with little tabs that say sign here, notarize here. Once the estate plan has been completely executed, the electronic copy will be available to you immediately, and Veterans Legal Institute will print out your portfolio and send it to you directly. If applicable, at that time, once we've received the notarized deed, Ahava Law will record the deed on your behalf. This is a very important step in making sure that your estate plan is properly funded. If you do not participate in the remote online notarization, then it is very important that after you have notarized the deed, you mail it back to Veterans Legal Institute so that we can get it recorded for you. Next topic is assessing capacity. Now this sounds like something that you're going to see on the movies and TV. I contest the will, they lacked capacity. The important thing to note is that under the probate code in California, the presumption is that you have the capacity to create your estate plan and to make your wishes known. If there is any reason to question your capacity, then your attorney or us here at the estate clinic will need to determine your capacity to make your estate plan. Capacity to make an estate plan is on a sliding scale. So if you come in and we talk to you and you know what you have and what you want to do with it and who your relations are and where you want to go and whether you want to disinherit someone and why, or whether you don't want to disinherit someone and why, as long as you can clearly articulate all of that to us, then we'll presume that you have the capacity to create this estate plan. Now, if there's any question of capacity, so for example, if you apply and you let us know off the bat that your spouse has dementia or Alzheimer's or something that might bring their capacity into question, then we're going to go ahead and ask that you bring a letter from your doctor saying that you or the spouse in question has the capacity to make these decisions. The determination is on a sliding scale, so it may be that you do not have the capacity to contract, but you do have the capacity to make a will. And in those cases, if the trust is in alignment with a simple will, we could do that. However, if it determines that you don't have the capacity to contract and the trust is not in alignment with a simple will, then we would only be able to create the will on your behalf. So this is a very, very important thing. But the truth of the matter is it's a non-issue 99% of the time and truly only is an issue if you make it one. But if you come and you know what you want and who you are and where you want your stuff to go, then capacity shouldn't be an issue at all. Next, we're going to talk about the estate planning documents. An estate plan is not a single document. It is a series of documents that cover all aspects of planning for your life, incapacity, and eventual death. As part of the estate clinic, we provide several documents as a package for each of our clients. These packages are tailored to the specific needs of the clients, but all of them include the same key documents. The primary cornerstone of which is usually the revocable living trust. And the revocable trust, as attorneys know, is the contract which governs their assets both during life and at death. And for our clients, we like to say that the trust is the treasure chest that holds all of your assets and protects all of your loved ones. And you are creating the map to that chest that says exactly how it goes, where it goes, when it goes, why it goes. The other document that we include is a certification of trust. This is a short document. The trust can be 50, 100, 200 pages long. The certification of trust is generally about 3 to 5 pages long, and that gives a short summary of the terms of the trust. This is the information that is necessary for banks, financial institutions, mortgage holders, etc., to give them the information they are entitled to with regards to the trust, while protecting the privacy of the trust, because the information contained in the trust is personal, private, and confidential to the client. The other document that we include in our estate plan is a pour-over will. Pour-over will is necessary for 2 reasons. The first being as a catch-all in case there are any assets that were not properly funded into the trust, either because they were acquired thereafter or for whatever reason. It says that anything not in my trust, I put it into my trust now. The other reason that a will is incredibly important is if the client has minor children, because that is where the legal nomination of guardian is for establishing who will take over legal guardianship of the children if, God forbid, the client should pass away before the children attain the age of majority. The other document that we always include for the client and the client's spouse, if there are 2 people in the plan, is the durable power of attorney for finances. The durable power of attorney for finances, we generally use the California statutory form. However, we have it significantly enhanced to cover a lot of the common aspects that need to be covered. The durable power of attorney is what allows the designated person, usually the other spouse as the primary person, and then thereafter the respected and trusted fiduciary, whether that be a family member or friend. And that allows them to make financial decisions on behalf of the client when they are unable to do so for themselves, whether that's paying bills, dealing with the IRS, wrapping up businesses, etc. The durable power of attorney can be either a immediate power or a springing power. Generally, for clients, we set it up so that it is immediate with respect to the spouses, but springing with respect to any other fiduciary. The next document that we always include is the Advanced Healthcare Directive, the document that outlines the client's specific wishes with regards to their medical care in the event that they are unable to articulate their wishes themselves. This includes decisions such as whether they would like blood transfusions, whether they would like organ donations, whether they would like to receive medication even if it hastens their passing, whether they would like to pull the plug or stay on machines until the absolute end. All of these decisions are personal, and each client gets to make that decision for themselves, and it is our job as attorneys to make sure that those are properly recorded in their Advanced Healthcare Directive. It is important to note that there is the Advanced Healthcare Directive recognized by the state of California, which we provide as part of our estate plan for each of our clients. There is also the VA-specific healthcare directive, which many clients have completed at the VA itself. We need to make sure that clients know that the VA-specific form is only valid at the VA, whereas the Advanced Healthcare Directive that we complete as part of their estate plan is valid at any medical facility nationwide. And it's not always possible that they're going to be rushed via ambulance to the VA clinic. It's quite possible they might be rushed via ambulance to the nearest clinic. So it's very important to have the Advanced Healthcare Directive, the California version. The next document that we include in our estate planning portfolio are the final disposition instructions. The final disposition instructions is the document that says exactly what you or your client wants with the remains when you are gone. Do you want to be buried in a national cemetery? Do you want to be cremated? Do you want to be scattered at sea? Do you want to be put in the family plot with your spouse and loved ones? Whatever the decision is up to you. But it's important that we make sure to note in the final disposition instructions exactly what your wishes are and who you want to be in charge of carrying out those wishes. Another document that is included in the estate planning portfolio, if applicable, is the standalone nomination of guardian for minor children. We generally do this as a package that includes not only the standalone nomination, which nominates a guardian both temporarily and permanently, but also we include a power of attorney and a power of attorney for healthcare for the children, which allows a designated person to take care of the children when the parents are unavailable. Maybe it's because they're taking a well-deserved vacation overseas and the children are staying with grandma and grandpa for a week, or maybe it's because of an emergency health situation and the designated persons will be caring for the children longer. Either way, we want to make sure that those guardians have the ability to enroll the children into school, take the children to doctors when needed, and so on and so forth. Another very important document to include in the estate planning portfolio is the deed. If the client has real property, especially in California, it is very, very important to prepare the appropriate deed, transferring the property from the current ownership, whether it's owned as an individual, joint tenants, community property with right of survivorship, tenants in common, whichever way it is owned, it needs to be transferred to being held in the trust. Finally, we also prepare ancillary documents as needed. These include things such as assignments, summary of all of the documents included, any pre-need forms, and this will vary significantly based on each client. For example, in the estate clinic, we once had a client who owned several trademarks, and so we wanted to be sure to specifically put those trademarks assigned into the trust. So, as I mentioned, your entire estate planning portfolio will be very unique, and it will be made up of several documents, usually about 6 to 12 documents in each complete plan.
It's important that you fund your trust because a trust only protects assets that are properly titled in the trust. And if the trust has no assets in it, it's a non-entity. We will provide trust funding instructions when we send you the packet. It'll explain how to use the certification of trust to go to your bank and get your bank accounts into the trust. We'll explain how to update the beneficiaries in your life insurance. and retirement accounts, etc. We will also, because of the generosity of Ahava Law, be able to record your deed. We will ask that you do pay the recording fee with the county.
Next, we're going to discuss VA benefits as they pertain to estate planning. It's important to know that VA benefits is a huge topic, and there's a video that summarizes all of that. But in terms of estate planning, there are 3 things that you, the veteran, need to know. 1, apply for your benefits as soon as possible. If you have not already done so, do so today. The longer you wait to apply for benefits, the less that you will be entitled to or able to receive. And you've earned those benefits, so please apply and use them today. For example, if you immediately upon discharge walk across the hall and apply for your benefits, often you will receive full dental as well as medical and all of the other benefits you're entitled to. However, if you wait a year, you will no longer be eligible to receive those dental benefits. So it's very, very, very important to apply as soon as possible. The best day to apply for benefits is yesterday, just like the best day to create your estate plan is yesterday. Because if you wait to create it when you need it, often you will no longer be able to create it, either due to death and incapacity. Specifically with your estate planning, there are 2 VA forms that you should know about. First is the VA pre-need eligibility form. It used to be that you had to die before your family could find out whether or not you're eligible to be buried in a VA national cemetery. However, now you can go online and complete the form 40-10007 and apply to determine your eligibility to be buried in a national cemetery now. A separate application needs to be completed both for you and your spouse, and both applications will need a copy of your DD-214 form. It's important to note that this form only applies to national cemeteries. So if you want to be buried in a state veteran cemetery, then you need to check with that cemetery specifically to see what forms they require. Please note that if you are buried or interred at a Veterans National Cemetery, then your spouse will be included with you. If you choose to be buried or interred at a state veteran cemetery, your spouse can still be buried with you, but you'll need to pay for their burial separately, which is currently $893 in California. The other form that you need to know about is the VA Burial Allowance Form, which is form number 21P-530. This is the form to fill out to get allowance for being buried in a cemetery other than a national or state veteran cemetery, and includes such things as the medallions and headstones needed for burial on any cemetery.
If you are a veteran who is interested in having estate planning services through Veterans Legal Institute, please go to the Veterans Legal Institute website at www.vetslegal.com/application and complete the application. This video was made possible by a generous grant from the state of California. This video provides general information relevant to the state of California and is not to be construed as legal advice.